Mullah. There was a WAQF Act of 2013.
2013.
2013. 19, huh? Will you allow me? 2013, then, 1913, 1923, 1913, 1923.
First in 1923.
1913, 1913, then 1923, then 1913,
1913, 1913,
1913, then 1923, then 1954, then 1984, then 1995, then 2013 and 2025. This is the history of it.
Sequence.
Yes.
Just factually, 84 and 2013 are amendments, not the new.
No, I'm talking about the act.
Yes.
Correct? So, therefore, and I will demonstrate to your lordships that the 2025 Act is a complete departure from the past. I'll tell your lordships how. There are two concepts in law called waqf by user and a dedication which is made. Right. If you give a dedication, mullahs, and you pass away, and that property is used, mullahs, for the purposes of the dedication, it becomes a waqf by user. And it's perpetuity. That's the concept of waqf. Once a waqf, always a waqf. Correct, mullahs? Now that waqf by user has been done away. A concept that is recognized in the Babri Masjid case, saying waqf by user is a practice, a religious practice, that has continued for hundreds of years. That's the 5-judge bench, mullahs. And whether it's a waqf by user or not is a matter of evidence. But they've done away with it. How have they done away with it? They say that in the 1913 Act, the 1923 Act, the 1954 Act, and the later acts, there was a requirement for registration. And because you did not register, mullahs, therefore, any waqf which is not registered will not be regarded as waqf. So many of these waqfs by users were created 100 years ago, 50 years ago, 200 years ago, mullahs, 500 years ago. Where will you get them?
Is it a matter of fact that under those enactments, 1913, 1923, and so on, is there a requirement for registration?
There was.
So is it a mandatory or
It will no. They shall be registered, they said. But notice the consequences of non-registration were not set up in the Act. The consequences of non-registration, this is the first time in the 2025.
I have not gone through anything because I had.
That's why, Manoj, I'm broadly telling your lordships what my submissions are going to be.
I have not gone through. I'll be frank, so you'll have to start from ABCD.
Yes.
Just as a matter of information, as whether under the old Act,
Yes.
the provision was for registration was mandatory or directly?
The expression used was shall.
Merely using shall may not make it mandatory.
Correct.
Were there any consequences provided in those acts for non-registration? If consequences are provided, then it will be mandatory. Whether word shall is used or not.
No, Manoj, the consequences were not that it will not be regarded as a waqf. That was never the consequence.
Was there anything that on account of registration of a particular?
You won't be regarded as
something will happen.
No, there's no consequence that you will not be regarded as a waqf. It will continue as a waqf.
But there were consequences.
No, not this consequence.
No, but
So
For the caretaker, there may be consequences, but not this.
Please record your submission.
Yes, please.
That though under the old Act, there were requirements for registration, but they were not mandatory because the consequences for non-registration were not provided under those Acts.
For the purposes of deciding.
On account of non-registration,
Yes,
nothing was to be happen.
yes,
Like suppose if there is under certain Act, mandatory duty is there. You have to do such and such thing within a particular period.
correct.
And if you don't do that, then you will be required to pay 1,000 rupees fine or 1 lakh rupees fine. So no such provision is there.
No. The only thing was, Manoj, that the Act said that the mutawalli who has not done it is made culpable. That's all. He loses his right to continue as a mutawalli.
That's all. There
So
was,
that's all. That I said to your lordship, and I stand by that. There were no consequences provided that it will no longer be regarded as waqf,
no,
which is
no other consequences were there.
no other consequences, which is why the 2025 takes that away.
So
Therefore, it's a complete departure.
so do we record that?
Yes, your lordship may record it. It's a complete departure from the
No, that
19
under 2013, sorry, 1913, till what was the last one, 1913 till 2013.
till 2013. The status of the waqf,
2013,
yeah,
though,
the status and character of the waqf.
no, though
continue.
there was a provision
Yes.
for registration of
Yes, yes,
a work.
yes.
No consequences were provided.
Right.
Were provided for non-compliance, except removal of a mutawalli.
Correct, because he is responsible for registration of the waqf.
So they except removal of a mutawalli,
Yes. Consequences qua the mutawalli.
not a trust, not a work.
Correct. Well, that's for the community, Malat. So because he did not register, he will suffer the consequences, but the character of the waqf will not change and cannot. This changes it. I'm just giving you lordship broadly. This changes the character of the waqf. It says if you're not registered under these acts, then you're no longer waqf. That's number one. Number two, if you are a waqf by user, you must tell us as to who is the one who established the waqf. Well, how do we know? If it is established 200 years ago, how will anybody tell you today who established it? Because there was no registration at that point in time. They were user. That is why waqf by user is a matter of evidence held by the Constitution bench of this court.
1913 to 2013.
Yes. Well, 23 was the first one actually.
Whether during 1913 to 2013, registration was not necessary insofar as work by user is concerned.
Yes, yes. They have now removed it completely.
Was it permissible under the?
Yes,
Code
yes,
Act?
yes, yes, yes. Yes, yes. Throughout, Manoj, otherwise I wouldn't be making this submission. Works by user, this is established practice, recognized by
Yeah, so
the Constitution bench of this court.
second submission is that prior to 2025, work by user was not required to be registered.
What happened was, Manoj, in 1954, for the first time, there was a requirement of registration as such. Otherwise, 23. Yes. मैं कह रहा हूँ यार तुम बता रहे हो गलत बोल रहे हो।
2020.
Your lordship may say prior to 1923 or prior to after 1954, Manoj, what happened was when the British were here, they didn't want to interfere in the practices, religious practices. Provisions or management provisions, Manoj, in those acts. But in 1954, it became mandatory that you must register. Now, who was to register? The mutawalli. The mutawalli was not.
Prior to 1954,
Yes.
registration of work by user was not necessary.
No, nobody was questioning work by user ever. Till date, Manoj, nobody is questioning except this act, except the 2025 act.
Probably you have not understood the question. What we are only asking you, was it mandatory or required to be registered as a waqf under the acts prevalent at that relevant time as a waqf?
After
Maybe by
1954,
waqf
yes.
by user.
After 1954, yes.
Yes. So
Yes.
after 1954.
Yes.
The registration was mandatory.
Mandatory.
And it had to be-
Even insofar as work by user is concerned.
Yes, yes. Even by works by user. All works had to be registered. Mutawalli had to register them. If he did not register them, then consequences followed qua here.
Consequences on the only.
That
But
we'll see into
the
that.
Waqf property did not lose its character as Waqf. That's the point.
So according to you, prior to 1954,
Yes.
registration of work by user was not necessary, and it became necessary after 1954. Was not necessary.
2025.
I'm saying that, but these fellows are either saying 23 or.
Only after 1954 it became necessary.
Yes.
Only after 1954 it.
Mullah, there is some confusion on this, maybe after 23, after 1923. Your Lordship may write 1923 because,
Okay.
Yeah.
So we'll write.
say 1923, Mullah, not
We
1954.
are recording everything so that we can call upon them to answer all.
1923 because I've read the act myself. That's why I was saying 1923. 23, Mullah.
Problem is that
All Lords,
so much of pressure,
yes.
not only builds pressure on us, but also on you.
Yeah, exactly, Mullah. I got different discordant voices here. 23.
So therefore, we are,
Yes, just I show you that the 23 Act says within 6 months from the commencement.
first we'll
Yeah.
first we'll record your proposition.
Yes.
So that,
Yes, so that we know,
My
Mullah, what.
friends, not to disturb Mr. Sibal, my lord. He's continuously being disturbed from all.
That's all right, don't worry about it, I'll take care of it.
Yes. You must.
he is trying his best. We can see it in a better manner.
Yes, yes, my lord.
Yeah, because-
Others may not disturb.
We can see it in a better manner. He has tried at least half a dozen times.
So, therefore, that's the proposition. Let's make it 23, not
Okay,
54.
23. After 23, it was necessary.
Yes, necessary. But no consequences square the dedication.
So that we already recorded.
Yes. So, Mullah, that's the second proposition. You take away Waqf by user. Third proposition is, Mullah, just note two dates, 1904 and 1958. These acts relate to Ancient Monuments and Archaeological Sites and Remains Act of 1958. And there is the 1904 Act, which is also here, which is the Ancient Monuments Preservation Act of 1904.
Ancient monument.
Preservation Act 1904. So two acts, 1904 and 1958, both dealing with ancient monuments.
Both 1904 as well as 50.
And 1958. So, Mullahs, when this 1904 Act came, Mullahs, as your Lordship knows, Waqfs were there. Right, the
The
dedication.
works were from centuries, we are saying that there.
Waqfs have been there, Mullahs. So what the Act did not interfere. For example, Mullahs, you have, say, the Jama Masjid or any other places of work.
Let them argue.
I'm feeling happy that I have only 6 more months left here.
We are not happy, my
So
lord.
by experience of 18 years in the High Court,
We have-
compared to the 6 years here, has been much, much better.
My lord, that I can also say, my lord, for High Court, my lord, because I have also come from High Court, so is my learned friend.
But those practices are not being followed here, Mullahs, despite the fact that people come from the High Court.
Yes, my lord. So we learn wrong things, my lord, from our seniors.
That's the problem.
Yes.
Anyway, Mullahs, I think
Then let's proceed, yes.
let's proceed. No, Mullahs, kindly just leave your paper book for the moment. I'll tell your Lordships what the contours of my submission are. Mullahs, this is a case in which the 2025 Act has been framed, Mullahs, for the purposes of protection of Waqfs. But in reality, it is designed to capture Waqfs through a process which is non-judicial, through a process which is executive, through a process in which those to whom this property belongs, because Waqf can't be created without, except through private properties owned by the individual concerned. So private properties are being taken away only because there is some dispute. We don't know what the nature of the dispute is. And when that dispute happens, Mullahs, a person is appointed who is higher than the collector, and that person will decide the dispute on his own. He will give a report, but by the time, Mullahs, that report is given, we don't have the time frame. And within that, Mullahs, while that report is pending, the Waqf property is taken away. And
It's taken away without following due process.
yes, and without following any procedure. I'll demonstrate all that to your lordships. Taken away with, and the dispute is whether this is government property or my property. He will decide that. He is a nominee of the government, who is higher than the collector. So the government decides its own dispute without any judicial procedure. And while that dispute is pending, while that report is pending, the property is taken away. It is no longer Waqf property. And there is no procedure. And anybody can create a dispute. So this is one aspect of the matter, which is in the context of what I say, it was designed to take over and capture Waqf properties. That's number one. Number two, Mulats, what is a Waqf? A Waqf, Mulats, is a endowment to Allah, to God. A dedication to Allah, to God. And that, pursuant to that dedication, that property can't be dealt with in terms of transfer. You can't transfer that property to anybody. Once a Waqf is always a Waqf. That's the very concept of a Waqf, Mulats. In other words, if I have, Mulats, in fact, dedicated my piece of property, because I cannot dedicate somebody else's piece of property. And the historical reason behind it, let me just tell your lordships that, is that, as your lordship knows, under our constitution, Mulats, the state cannot possibly finance religious institutions. Cannot finance, Mulats. If there's a mosque, Mulats, the state cannot finance it for its upkeep. If, Mulats, there is a burial ground, this has to be created through private property. So what happens is, Mulats, that people at the end of their lives, Mulats, give their private property dedicated to God, so that those who come later, Mulats, can take advantage of that property. There are no earnings there, Mulats. If you go to a burial ground, Mulats, nobody earns. People come to bury their dead bodies, Mulats, and they charge a certain amount through which they maintain that. If you go to a mosque, Mulats, there's not a chadhava, Mulats, like in temples. They don't have 1,000 crores, 2,000 crores, 3,000 crores, Mulats. There are no chadhavas in mosques. So those have to be maintained. And how are they going to be maintained? Through the kind of monies that we collect through processes, Mulats, of charity. That's all.
That happens in other religions also. When temples are...
No, but temples, Mulats, people give, as your lordship knows, Mulats, there are chadhavas that are given, Mulats, and temples are, in terms of, Mulats,
But even in the...
mosque.
I visit dargahs also, I visit churches also, everybody...
Dargahs and mosques. Dargahs and mosques are different. Dargahs and mosques are different. I'm talking about a mosque, Mulats. Your lordship is right. On dargah, it's different. But I'm talking about mosques. So what I was trying to say was, Mulats, the ways to preserve these properties is through these kind of efforts that are made by the community. Right? Now, Mulats, what they say is that if anybody, supposing an encroacher creates a dispute, that property will lose its character as Waqf property as long as the dispute is pending. This is what the Act says. So you have a situation, Mulats, where actually there was a Waqf Act. Just note this, Mulats. There was a Waqf Act of 2013. 2013. 19, huh? Will you allow me? 2013, then, 1913. 1923, 1913, 1923.
Was in 1923.
1913, 1913, then 1923, then
1913, 1913. 1913.
1913, then 1923, then 1954, then 1984, then 1995, then 2013 and 2025. This is, Mulats, the history of it. Yes.
Just factually, 84 and 2013 are amendments, not the new.
No, I'm talking about the Act.
Yes.
Correct? So, Mulats, therefore, and I will demonstrate to your lordships that the 2025 Act is a complete departure from the past. Tell your lordships how. There are two concepts in law called Waqf by user and a dedication which is made. Right. If you give a dedication, Mulats, and you pass away, and that property is used, Mulats, for the purposes of the dedication, it becomes a waqf by user. And it's perpetuity. Because that's the concept of waqf. Once a waqf, always a waqf. All right, Manoj? Now that waqf by user has been done away. A concept that is recognized in the Babri Masjid case, saying waqf by user is a practice, a religious practice that has continued for hundreds of years. That's the 5-judge bench merge. And whether it's a waqf by user or not is a matter of evidence. But they've done away with it. How have they done away with it? They say that in the 1913 Act, the 1923 Act, the 1954 Act, and the later acts, there was a requirement for registration. And because you did not register, Malaj, therefore, any waqf which is not registered will not be regarded as waqf. So many of these waqfs by users were created 100 years ago, 50 years ago, 200 years ago, Malaj, 500 years ago. Where will you
But
get
is
them?
it a matter of fact that under those enactments, 1913, 1923 and so on, is there a requirement for registration?
There was.
So is it a mandatory or
It will, no, they shall be registered, they said. But Malaj, the consequences of non-registration were not set up in the Act. The consequences of non-registration, this is the first time in the 2025.
I have not gone through anything because I had.
You know, that's why, Manoj, I'm broadly telling your lordships what my submissions are going to
I
be.
have not gone through. I'll be frank, so you'll have to start from ABCD.
Yes.
Just as a matter of information, as whether under the old Act,
Yes.
the provision was for registration was mandatory or directly?
The expression used was shall.
Merely using shall make. The present batch of applications pertains to an issue as to whether the officers in the Indian Administrative Service, the reporting authority, reviewing authority, and accepting authority of the officers working in the Indian Forest Service. The present applications basically challenge the government order dated 29th of June 2024, notified by the government of Madhya Pradesh with regard to writing of performance appraisal report of the officers belonging to the IFS. The applicants have a grievance with regard to paragraph 2 and 3 of the CJI also. We are referred to certain clarifications and office memorandums issued by the Union of India. Clause 4 of the clarification dated 28th of December 1990, which is to emphasize that in assigning reporting authority, due regard must be had to seniority and pay scale of the reporting officer vis-a-vis a member of the service reported upon. It notes instances where ACRs were initiated by officers the same batch or pay scale as the officer reported upon, and according to advices state governments to avoid such assignments. Further state that, as far as administratively feasible, the reviewing authority should be in a higher grade than the reporting authority. We are referred to the judgments given by this court in the case of State of Haryana versus PS Wadhwa and the order dated 22nd of September 2000, passed by this court in this very proceeding in the case of Santosh Bharti versus State of Madhya Pradesh. It is pertinent to note that this court in the order dated 22nd September 2000 had specifically considered the issue with regard to who should be the reporting authority, the reviewing authority, and accepting authority, insofar as officers of IFS are concerned. It is further pertinent to note that the state of Madhya Pradesh had also filed an application seeking modification of the directions given by this court in the said order dated 22nd of September 2000. This court in the said application had called for the report of the CEC. It was accordingly submitted and was accepted by this court. After considering the said report of the CEC, the application filed by the state of Madhya Pradesh was rejected. The legal position as approved by this court, two separate orders of this court, and as rightly understood by the MOF, as could be seen from its letter dated 8th of November 2001, is that insofar as the writing of ACR up to the rank of APCCF is concerned, the reporting authority should be the immediate superior authority in the forest department. the position is clear as regards reviewing authority or reporting authority in relation to officers up to the rank of APCCF. It is clear that except the PCCF, the reporting authority has to be a superior officer from the IAP. It is only with regard to PCCF that the reporting authority would be a person to whom he reports and who is superior to him in rank. No doubt that if necessary, the state government can provide that the collectors and commissioners can record their comments on a separate sheet about the performance of the IFS officers in relation to the implementation of developmental work funded by the district administration. However, the same is again required to be considered by a superior departmental officer of the IFS. Further, consider you that the GO dated 20th June 2024 is totally in violation of specific directions issued by this code, while its order dated 22nd September 2000 and 19th April 2004. Perusal of the table annexed and Annex 8, the compilation of the learned amicus would reveal that except the state of Madhya Pradesh, all the other states are scrupulously adhering to the directions issued by this court in the opposite order. There is no hesitation to hold that the impugned GO is rather contemptuous in nature, in as much as the said GO, which is in violation of the opposite orders of this court dated 22nd September 2000 and 19th April 2004, has been issued without even seeking clarification, modification of this court. You could have very well proceeded to initiate contempt proceedings against the officers responsible for issuance of such GO. However, we refrain ourselves from doing so. GO being in violation of the directions of this court is liable to be caught and set aside. The result, the applications are allowed. The impugned GO dated 29th June 2024 is held to be in violation of the orders passed by this court in the present proceedings dated 22nd September 2000, which is reiterated by the subsequent order and is therefore quashed and set aside. State of Madhya Pradesh is directed to reframe the rules by strictly adhering to the directions issued by this court by the order dated 22nd September 2000 in the present proceedings, which have been clarified by the MOF in its letter dated 8th of November 2001 and also clarified by the DOPT by its letter dated 2nd September 2004. The same shall be done within a period of 1 month from the date of this order. We place on record our appreciation for the efforts put in by Shri Permission, Learned Amicus Query for extending support and suggestions, and Shri Tushar Mehta, Learned Solicitor General, for taking a fair stand on behalf of the Madhya Pradesh.
Great. The Lordship's permission, the press, at seal number 30, there is no possibility. No, there's actually still mentioned. I'm sorry.
Mentioning
Yes.
My lord, this is a matter relating to the judicial officers of Madhya Pradesh, my lord. We are seeking the same relief which is granted to Telangana officers. A very short point. And it was detagged from all India judges for this very reason. And my lord, the matter is being shown from time to time in the list, but not being listed.
What is the relief you are seeking?
The age of superannuation.
That's for every state to decide how can.
No, state is agreeable. Now they say because of the pendency and directions in all India judges on earlier occasion, unless this honorable court gives a clearance, we will not do it. They are ready, my lord. There's no difficulty about that.
Who is appearing?
For the state, my lord, Haman is on record, my lord. Last time he appeared, and his affidavit also, my lord, they, even recently, we made a representation to the High Court. High Court says unless the honorable Supreme Court clears it, we can't do anything.
They want to make it 61.
Yes. Not 62, 61. 62, because Telangana has granted 61 by this court.
That's it. It can't be 62.
Yes.
There has to be some.
Let it be listed next week also, my lord. We have no issue.
Okay, next week.
Next week.
Your Lordship, this is related to Sariska Tiger Reserve. Your Lordship has passed the directions on 11th December to constitute a committee and then implement the recommendation 1 to 6 and 15. However, they have implemented recommendation 1 without constituting a committee, and they have banned the entry from all the gates now and without hearing the trust.
They have banned the gate entry.
Entry, yes, without forming the committee, without taking any instruction.
Well, you know what has happened in. No, but Sariska, we have directed them to provide for electronic buses and all that.
Yes, Your Lordship, they have not done anything. They have not.
Give a copy to Mr. Parmeshwar and the Council for the State of Rajasthan.
Yes, Your Lordship. We have served though. We have served them.
There are two matters in 803.
next week.
It's there in the next week.
This is there
You
next
give the list of the matters which should be listed.
Hand over to the court.
Malad, there are two matters in 803. Malad. The first one is mine, Malad, if I may mention. Malad, 125603. No, this is regarding Malad's heavy destruction of forest Malad in Khasi Hills, especially the Riboi district, Malad, where a university campus is coming up and there are several illegal mining.
All fresh hires we have put next week.
Malad, if my lords may kindly post it
fresh
along
hires
with
are
the
coming next
development matters.
All fresh hires are coming next week.
Next week, Malad. I am grateful.
That list I have passed on to the court master.
Yes.
We have supplied a copy to the learned amicus, Malad.
We'll have them in the next week. Yes.
Grateful.
Plus, according to your lordship schedule, we'll have all the fresh matters on Monday itself, so that the first half, all the fresh matters are done. Because then the bigger matters can be taken.
Bigger matters.
Bigger matters.
Which matters you are listing?
Balco is there, Matheran is there. Your lordship has listed those two specifically final disposal. That might take some time. Then Aravalis are there. That's about 400 IS are there in the Aravali matters. So those might take some.
400.
400. But
How many have you cleared till now? How many have you cleared till now?
From October 22, this must be around 800, 900 IAs would have been done by now. 900 matters by.
Next week, yes.
Great.
Oral mentioning only matters which can't wait till Monday. If somebody is dying, somebody is being hanged, somebody's house is being demolished. Otherwise, if anybody mentions that matter, we'll directly dismiss it at this stage of mentioning. Otherwise, all matters will come in the next 2 weeks. And what is this? When the judges are willing to work in the vacation, first 5 judges are sitting in first week. And the blame is on us because of the pendency. It is the lawyers who don't want to work in the vacation.
Some lawyers. Some other lawyers want to work throughout vacation.
For different reasons.
They are not being placed for the last 4 months. And we have no choice because this is a referred matter. And there is a judicial order passed saying that please place the papers.
Which matter?
I have this order is passed, judicial order. And we are changing with the registry and they said you file an IA for implementation of the judicial order. Your Lordship may just call for the papers and fix any date we are ready to go.
First, we'll have to constitute a 3 judges bench because
Any regular bench, my lord. We have no.
no, the order says it says.
Yes, it has to be. It is a reference.
Judicial order, so we are bound by it.
It is referred to a larger bench.
July में देख लें.
I fall in that category.
Let us see. If you don't fall in that category, we'll dismiss it right now. Choice is yours. We have made it loud and clear. Otherwise, all those matters will be listed in the next 2 weeks.
I'll tell you why. I believe your lordship was already day before yesterday on this mentioning directed. Day before yesterday on this mentioning, my lords had directed that since Justice Narasimha is on leave, any bench where Justice Bagchi is sitting should be listed before that. This is what Justice Narasimha had intended. It's a formal orders only. That's all there is to be reminded.
What is the urgency in that? It can
Urgency is that they...
we'll direct it to be placed before Justice Narasimha in the vacation.
Justice?
Narasimha, when he comes back, we'll directly to place before him in the vacation.
Only one thing, Justice Narasimha himself had said, subject to orders, Honorable Chief Justice, he and Justice Bagchi heard from formal orders, a security of 300 crores has to be substituted. ED has agreed. What is happening? The main security is being held up.
So he's sitting in the vacation, we'll directly to be placed before him.
He's coming on 30th is what I am told, subject to correction. I am told it's 30th of June.
Can wait
For
till then.
formal orders only of substitution of security, ED is agreeing, Wallace. ED is agreeing.
Wait till he comes.
Lords, item 15.
They're verified.
Item 15, if I can, Lords.
Vacation में लगा लीजिए उनके सामने.
May I mention?
There is a matter where it's already been listed, the registry has taken it urgently, listed it on Monday, but it's an MA for a recall of Justice Parthiwala's order. Justice Parthiwala is not sitting on Monday. Could it be on Friday?
He is not sitting in.
He's not.
He is not sitting in vacation.
That's the problem. So that it's for a recall of his order where, as the petitioner had appeared, a detailed civil appeal judgment was passed. Respondents were not called upon. No notice was issued. Caveat was there not honored.
लगा लीजिए Friday.
That's the
Your Lordship, I am also in one of the connected MA.
820.
Lords, may I make a request?
Your Lordship, I am also in the connected MA. I am also in the connected MA in the same matter in which Gopal sir had mentioned. That may also be.
Matters which were directed by your lordship's bench, my lords, to come up on a particular day. This particular bench,
Obliged.
your lordships, my lords, on 20th, had to go back the matter, my lords, because it was an.
What is the urgency?
It was, so can I pray for it to be next week, my lord? Not this week, next week. Since your
Next
lordships.
week we would be taking a green bench matters. What is the urgency?
It was a criminal appeal where I've been convicted in a reversal. The judgment of the High Court was sort of indecipherable, my lord. So your lordships had intentionally kept it after 8 weeks. So it had to go back to Punjab and Haryana. So that was the matter, my lord. So
January 26th.
My Lords, may I request?
since your
In
lordship.
number 30.
January 26th.
Lord, may I mention a fresh matter? Last week also. it was-
I told you, don't mention otherwise, it will come in July.
No, since we wanted to work in the holidays, my lord, that's why I was mentioning.
We would like to concentrate the next week on environmental matters.
All right. I'll mention it in July.
My Lord, see, number 30 is a bail matter. Last week it could not be taken up. He is 68 years of age. My Lords, may I have in the next week. See number 30.
We are already telling you, you come through the regular mentioning procedure, everything will be listed in the next 2 weeks.
My Lord,
In spite of you want to mention, we'll dismiss all such matters.
We will do that.
permission, may I mention matter? Your Lord.
So this matter, 54 persons are already released from their job. The
beg
matter
pardon?
was listed before Justice Narasimha and was directed to be listed on 19th of May. But your lordship may kindly keep it.
Keep it in the vacation before it.
Vacation with your lordship next week because they are already released from their job and the recruitment.
Nothing will likely to happen in 3 weeks.
Your lordship, recruitment process has completed. It is just a matter of the.
Let it be listed in vacation before it.
May I mention, my lord, fresh
Item 11, your Lordship, application is for extension of time to surrender is expiring tomorrow, your Lordship. Time to surrender is expiring tomorrow, your Lordship.
When did you know that the time is expiring tomorrow?
Your Lordship, the appellant is a 70-year-old woman, she is hospitalized only for extension of time.
Next week.
Your Lordship, may I mention, Your Lordship, this is a fresh matter. Before 30th, Your Lordship, any day. Before 30th is election due, Your Lordship.
We are telling you that all those matters will be listed in the next week. Still,
But my lord, may I mention a fresh SLP, my lord, because this is important because this pertains to the construction of passenger jetty and terminal facilities are right in front of Gateway of India. So if the stay is not granted in that matter, if the matter is not.
did you approach the High Court?
Yes, my lord. In the High Court, the stay was not granted. That is the reason we residents have approached the Honorable Supreme Court now. So this matter may kindly be listed on Friday, my lord.
Next week.
My lord.
Lord, may be permitted to
Briefly
mention
over.
the matter, my lord. This pertains to the bench of Justice Samanunta. Lord, we mentioned the matter. I'm seeking recall of an ex parte order by which the order of anticipatory bail, which was granted by the Bombay High Court, has been, Lord, cancelled. Because we were never served, Lord, with the proceedings. Lord, I mentioned the matter in the morning. Lord, we were told to mention before your Lordship spoke.
Lord,
Your Lordship.
So there is a matter before Justice Padiwala's bench on Friday. That's a suo motu notice relating to some suicides which happen in coaching centers. So there are some petitions pending, my lord, in Delhi, Rajasthan, etc. We find the transfer. It's not tagged with the case of Friday.
Lords, may I mention, I want to mention one MA. Item 813 in the list for mentioning, my lords. This matter pertains to auction of a plot, my lords. This auction is tomorrow. This is a leave grant matter, SL.
When was the auction fixed?
Lords, I got to know about this advertisement last.
When was it notified?
Lords, the notification date is not there on the advertisement, Lords, but I got to know
When
last.
was it published in the advertisement?
Lords, it was published on the website, my Lords. It's not.
When?
2nd of May, my Lords.
What is today's date?
Lords, 21st, Lords. Tomorrow is the order.
Your Lordship, I want to mention one MA.
14 July.
Your Lordship,
May I mention the matter at 8181 mentioning list, an anticipated bail application.
818?
Yes, mentioning board. Unlisted. It's an application for petition for anticipated bail. High Court has rejected and may I request giving on Friday.
No, next week.
Your Lordship, I want to mention one MA.
Petition below, so next week I am comfortable.
But next week you don't have to mention. Just mention it to the
Lordship, I want to mention one MA. This is regarding the demolition happening in the slum area of Mumbai. And it is the demolition notice has come for the 27th. And the matter is supposed to be listed on Friday, 23rd. But Justice Vikramnath is on leave on that day. So I may request your Lordship to list it on with some other bench or.
What has happened before the High Court?
Your Lordship, High Court has not provided us with the stay, and partial demolition has already took place, and we have not been given the accommodation as promised by the builder. So the people are on road, Your Lordship.
Your petition is already dismissed.
No, Your Lordship. Yes, sir.
Your SLP is already dismissed.
Yes, Lordship. SLP was dismissed, and in the High Court, we were not given the time to.
Whether the SLP is dismissed?
Your Lordship, yes.
Then what is pending?
MA, we have filed one MA.
MA for what?
MA for the state that the demolition should be.
After the dismissal of SLP?
Yes, Lordship.
What is this procedure?
Because we were not being given the notice and we were just demolition to.
Were you heard by the bank of?
Your Lordship, at that time demolition didn't take place. The demolition took place after that.
MA taken on board, rejected.
So,
My Lord's permission.
Let it come in the regular course.
My Lords, may I have permission to mention a matter which my Lords yesterday in a mentioning, and somebody else is mentioning in a connected application in arising out of the same civil appeal. My Lords had allowed that to be listed on the 23rd. So I'm merely seeking that my application be tagged with that. I'm so grateful, my Lords.
May I mention item 815, my Lords, it is unlisted mentioning the number has been given. This is an extreme case where she is neck down paralyzed. We are serving lots her pro bono, but the only thing is she needs immediate medical need. She is now losing her voice, her finger sensation is also going. She's neck down paralyzed. Case facts are gross. I don't want to mention what that's.
No, it's a case for what?
Lots, we have filed a writ petition here.
For what?
Lots seeking Article 21 lots intervention of this honorable court. She needs to be provided some medical urgency. She has nobody around her. She's completely. I'm so very grateful.
820, interim protection has been vacated with the High Court on 14th May. I had interim protection, husband and wife in 420 case. All I'm requesting for next week's Malasur.
Next week we have been telling, I don't know why the bar doesn't want to listen what we are saying so many times.
Malaj, I am seeking liberty to mention, my written submissions may be taken on record. We had time till Monday. I have e-filed it on Tuesday. I'm seeking liberty for taking.
Malaj, may I mention item 823 in the unlisted mentioning list, Malaj. This is a tender matter, Malaj. High Court has dismissed on 15th, Malaj. It's regarding that Nauchandi fair, Malaj, to started from 25th, Malaj. Otherwise, it will become infructuous, Malaj.
Next week.
Malaj, 25th is the start date, Malaj. It may be tomorrow or Malaj.
Your Lordship, I am appearing for the petitioner wife in item 10. So here the mediation has failed and I am seeking transfer of...
Appearing for the other side.
Please, my lord, I beg to appear for the respondent in this matter.
Yes.
I am seeking transfer of this matter, section 13 petition from Ranchi to Bhubaneswar. I am staying in Bhubaneswar. I am also working in a company in Bhubaneswar. My child is studying.
My lord, the respondent here is a serving wing commander with the Air Force. He is presently posted in an active posting on the Western Front as part of Operation Sindoor. Those are my instructions. And secondly, he has been paying maintenance as accorded to the wife by the Air Force authorities. And secondly, he is willing to pay for all visits, whichever visit the petitioner here may be made to undertake to the family court in Ranchi.
Ranchi.
He is willing to pay.
So you are posted on the western front.
Yes, my lord. Those are my instructions. I don't have the details.
From there you want to come to Ranchi. And not Bhubaneswar.
My lord, it will be convenient for the respondent to handle his litigation in Ranchi, and he's willing to pay for the stay and travel whenever the petitioner here has to travel to Ranchi. He's willing to undertake the expenses.
Allowed people to appear. Video conference.
My lord, then in that case, the respondent may be allowed to appear through VC whenever he is physical.
Specifically that you don't want to
Much
listen
obliged.
what we are dictating.
Much obliged, much obliged. My apology, my lord. I am obliged. Grateful, my lord.
Rising out of the very same notification, Lordships have issued notice and that is pending. This is recruitment of district judges from the bar. Another candidate had filed a SLP at page 90. The Lordships have issued notice and that is pending.
Back, notice back.
Grateful.
Page 224 is the judgment of your lordships, my lord, which has granted relief to the identically situated petitioners. Page 224 is your lordship's judgment. Unfortunately, your lordships have affirmed the views of the other high courts. Madras High Court under the impugned judgment says we don't agree with the other high courts. The lordships will kindly see the order of your lordship. It is relating to the accounting senior assistant accounts officer and senior accountants, my lord. Revision of pay as per the 5th Pay Commission recommendation. That your lordship will kindly see all the other high courts decided in favor of the
Returnable 8 weeks.
Sir, that's delay. Delay. Delay may be.
This will be covered by our judgment now.
Just one submission, my lord. 10 months you've been asked to run, been forced to run from pillar to post. Can I request, my lord, to direct them to comply with that and then...
We have already directed and we have modified yesterday that all areas have to be paid within a period of 3 months.
10 months you've been, this is the only submission. 10 months after...
We have already directed areas to be cleared within 3 months.
Your lordship will direct that this also comply with that and then give
it. It is applicable to all judges in the country on a pan-India basis. As long as you are an Indian citizen, you will be covered by that judgment.
Peculiar.
And I don't think that any person who is not an Indian citizen would be...
Last 10 months, you have not been getting a pie by way of terminal benefit.
Judgment is already covered by...
Comply by, sir.
By our judgment and order that it's sponsored.
Your lordship will say comply.
We have already directed.
Right.
How many times we have to tell you?
No.
It's the 4th time that we are telling you that we have directed the areas to be paid within 3 months from yesterday. And it is applicable to all judges in the country. How many times you have to repeat that?
All right, don't have to. Only because of this, I pointed out. If your lordship would give a time for compliance, it would be good. All right, I'll take it then.
Please, I had a mining contract which was to expire on 30th of June 2023. The government, the state of Madhya Pradesh, we entered into an agreement on and by which we were granted an extension of 2 months on a condition of we pay 10% of the original contract amount. That is 2.75 crores I paid. Now, immediately thereafter, that document your lordship would find at page number 166, by which it was extended by 2 months. So I had to pay 10% of the contract amount. Later, on 7th of July, they issued a general order by which it was extended by 3 months. So what happens, everybody else gets it for free to lift the sand. It's not for excavation, to lift the sand. I am required to pay 2.75 crores. What I go to the High Court and I say
that permit extend that 2 months period because I have paid already paid 2.75 crores. But High Court says, no, you have been given 3 months period. That's good enough. But please have a look at that page 167. 167. Bottom, if your lordship sees. %10% I have to pay. So they grant an extension of 2 months. Now your lordship may please see the second circular, that's at page 206. This grants blanket extension for 3 months all throughout. And please see page 220. What they do is now.
Tell us what is the error in the.
That's the error. That's the error. The High Court doesn't consider that I have paid 2.75 crores. That has not been looked into by the High Court. That 10% amount I have paid to the contract amount. And therefore, if your lordship sees page 20.
That you have already been granted extension and you have.
But that was.
You are aware of that.
But what happened is this. If you, therefore, I was.
According to the High Court, it does not apply.
Therefore.
Or this is not a case of cancellation.
It's not a cancellation.
Therefore,
please see
clause which is applicable on which you are relying on.
Therefore, kindly see page 206 for a moment. Page 206. This is a blanket extension for all the mining contractor. Page 206. Page 206, if I am with your lordship. In reference to the above subject, the SAN group previously contracted in the district whose contract period till 30th of June 2023 and the period of stand storage license approved on under 18.6 of Madhya Pradesh so and so was till 30th June. Due to the sand mining being banned during the rainy season, sand is available from July to September. To ensure supply, the state government has taken the following decision. Now
whether in case also, whether in your case also it was banned?
Yes. So, my lord, I could have got extension otherwise. Now what happens is, please see this.
Where have you said so? That it was banned?
Yeah, it was banned throughout the state.
Let's see where you have the pleading.
Just show me.
And from the order.
Quickly. Actually, I think at least solar. No. Have you mentioned it? Maybe it's central. May I request to have pass it over, Lord? I'll just get the copy of the. But that rule is general. That rule
thank you. Thank you.
Your Lordship may pass it over. I'll just.
Thank you.
Lord, may I say in the alternative? Lordship.
Withdraw this and file a suit.
What happens is this. Only I happen to pay 2.75 crores.
You are on a different, totally on a different pedestal.
Lord, only one pedestal is different. I entered into a contract and then may I file a review, my lord. Your lordship may permit me to withdraw. I'll file a review and point this out that I paid 2.75 crores.
Allowed to withdraw with liberty to file for. I'll review.
I am so.
Please, my lords, I'm seeking a short passover.
What password now?
Please, my lords. My lords, this increasing incidence, my lords, of heat stress is today, my lords, affecting almost every citizen. Last year, my lords, more than 700 deaths took place, and I've handed over, my lords. There's a compilation of deaths which I have placed, my lords. Today, my lords, earlier, my lords, the predominance was only in 3 regions. That is the northwestern, my lords, central, my lords, today, and now, my lords, it has increased to all other, my lords, the East Coast, West Coast, my lords, the peninsular region, the southern region, the northeast, east, every region is affected, my lords. IMD report says that 70. Please. My lords, there are NDMA guidelines, there are national guidelines, my lords, because June is round the corner as sweltering heat is predicted. So, my lords, the short.
We have made it dinner with 2 weeks.
Please, my lords. Much obliged.
Which 49?
Yes, Lordship, please.
Yes, Mr. Solicitor.
My lord, with my lord's permission, I'm
sorry.
I don't want to disturb your lordship convention. The only thing is, my lord, since I have come from state of Jammu and Kashmir,
Thank you.
My lord, I have given a my lord breakup of the concept in the religious on the religious lines, my lord, in my application, and that is very important. Your lordship may require my assistance in that. Only why we read one paragraph, my lord, of my application.
Yes, Mr. Solicitor, you may begin.
Which, my lord, may reserve my lord right, my lord. Anytime, my lord, I can assist your lordship on that.
Assist at the stage of final hearing.
Lord, only one minute of
Sorry.
1 minute of your lordship's valuable time.
Sorry.
Lord, we are, Lord, a person, Lord, inside the JPC.
You may begin.
Lord, we have been participating in the JPC.
Are dealing with.
We can only make a request to your lordship, my lord.
Because this is a very important point, my lord, which was not argued before your lordship.
Concept.
Lord, that is why I wanted to place it before your lordship.
My lord, concept of WAQF by user, my lord, on the religious lines, my lord, has not been, my lord, fully, my lord, elaborated.
Don't do this. This is not done. Please, sir, I'm requesting you.
No, please, I'm just addressing to the court.
No,
I need not to take a permission from you.
You have said no yesterday, we will not hear anybody.
I reserve my, your lordship may grant me.
Lord, before the learned.
Sorry, Mr.
Permission only I'm asking.
Sorry.
Lord, this is with regard to the JPC.
Sorry.
If your lordship looks into our affidavit, that is enough, my lord. A rejoinder, I've made it very clear.
We'll read it.
Joint Parliamentary Committee, my lord, was not taken into consideration.
Mr. Wilson, yesterday you have said that we will not hear anybody.
Yes, my lord. Lord, two things. Yes. Not only JPC, my lord. Early morning, the bill was
very difficult to work here.
Obliged, my lord. Obliged.
There's no discipline, no respect for the court. Really difficult court.
Yes. Lord, please. Lord, your lordships have before your lordships, my lord, petitions filed by individuals, mostly, my lord, 99% in a public interest litigation and not by any affected individual. And that would, my lord, make the difference because your lordships are dealing with an enactment which is passed by the legislature whose competence is not in question. It's nobody's case that the parliament did not have the legislative competence to pass this law because this is one of the factors which is the possible only factor where stay of a statute is granted or something at that threshold that this legislature had no competence to enact the law. Now, my lord, I will just briefly point out to your lordships, my lord, what was the process, a detailed process which was undertaken, my lord, before the Joint Parliamentary Committee. I'll not read anything, but please, my lord, take my note and please come to page 9. I'm sorry, take my affidavit and come to page 9. My counter, my lord. My lord, counter. Lord, this is not a case where the ministry prepares a bill, it comes before the house, voting takes place mechanically, and the bill is passed. My lord, we were eradicating the menace which was noticed as back as in the year 1923, 102 years back. And therefore, my lord, we were very careful that each and every stakeholder is consulted, each and every voice is heard, and thereafter it goes before the parliament and a full-fledged debate takes place. Lord, please have a look at page 9, Lord, at para 21. Lord, this I would request your lordships to bear in mind. because it is my case that few of the petitioners cannot claim to represent the entire Muslim community. We received 97,000 representations. No, I'm sorry, 97 lakh representations. The Joint Parliamentary Committee had 36 sittings. Please come to page 9, para 21. Apart from the representations received by the Joint Parliamentary Committee, the Ministry of Minority Affairs also received representations. I'm sorry, my lord, my counter. From page 9, para 21. I'll be very brief and crisp. Apart from the representations received by the Joint Parliamentary Committee, the Ministry of Minority Affairs also received representations highlighting the need for legislative amendments which include mismanagement of work properties, deliberate encroachment and unlawful transfer of work land, inefficient functioning of work tribunals, sweeping powers to arbitrarily declare property as waqf as per section 40 of the Act, allegations against waqf board officials along with general grievances and representation from Ahmadiyya community. This is a schedule, very backward community amongst Muslims. Now, my lord, I'm not reading para 23. These are the state governments who were consulted. They came through their representatives. Then, my lord, page 11, para 24. My lord, 25 waqf boards were consulted. Consulted means they came, they gave their representations. There were deliberations with the Joint Parliamentary Committee. Clause by clause, and Joint Parliamentary Committee records that on this particular clause of bill, A board has this objection, B has this suggestion, C is agreeing, whatever. I'm not giving examples. Now, please see, my lord, page 12. We took inputs in personal meetings. We means the JPC with, my lord, these institutions, my lord, 28. I'm not, my lord, repeating All India Sunni Jamaat-e-Ulema, Indian Muslim Civil Rights, Uttar Pradesh Sunni Central WAQF Board, etc., etc. Lord, thereafter, Lord, a voluminous report was prepared where some suggestions by the stakeholders were accepted, some suggestions were not accepted, and they have given reasons why suggestions are either accepted or not accepted. When suggestions were made to amend some sections that it is not a part of the bill, please make it a part of the bill. Lord, the committee suggested that it should be made a part of the bill. And that bill was presented before the competent legislature and passed with, Lord, unprecedented debate. Now, your lordships, my lord, kindly come to my lord note. Lord, I have filed a note, my lord. I'll take your lordships one by one. One section after the other, my lord, which were under challenge. My note is confined to 3 issues, but I'll answer all issues, my lord, which were raised. Your lordships have my note. Lord, kindly come to page 4. 3R is quoted, my lord. Section 3, subsection R. Waqf means the permanent dedication by any person of any movable or immovable property. Please pause here for a minute. Lord, 1923 Act said a Muslim can create a waqf because waqf by a very nature is an Islamic concept. 1954 Act again said only a Muslim can create a waqf. 1995 Act also said only a Muslim can create a waqf. Now a very interesting amendment comes, my lord, in 2013, which came to be passed in November 2013. Incidentally, my lord, few months before the country was to go for general elections in March 14, where the inclusion was not Muslim, any person can create a waqf. Bear this in mind, my lord, and I'll come to, my lord, why this was done away with. Now, waqf means the permanent dedication, now amended, green is amended, any person showing or demonstrating that he is practicing Islam for at least 5 years of any movable or immovable property, having ownership of such property, and that there is no contrivance involved in the dedication of such property. Well, three things. A, he has to be Muslim. B, he has to be a Muslim practicing Islam for 5 years. And three, most important, he can create a waqf of the property he owns. He cannot create waqf on somebody else's property. This is to, my lord, eradicate the menace of encroachment of private or government property. Now, please see, my lord, this has a saving clause. I'll come to, my lord, justification on each of them. Please see the last. My lord, one more thing which we have added. My lord, just, my lord, a good thing, positive thing, my lord. Earlier, my lord, there is a concept of waqf al-aulad. Waqf al-aulad means that it's dedication of property to Allah, but for the benefit of my children. The children initially, till this amendment came, did not include daughters, widows, etc. This is introduced for the first time, not under challenge, fortunately. Now, please see, my lord, proviso. Provided that existing waqf by user properties registered on or before the commencement of the Waqf Amendment Act 25 as waqf by user will remain as waqf properties. My lord, kindly pause here for a minute. This is a prospectively applicable provision. If you have registered yourself as waqf by user, then it is saved. With two exceptions. Except that the property wholly or in part is in dispute. Lord, kindly pause here for a minute. I have not clarified in the affidavit that dispute would mean a private party may have a dispute with the property of the waqf. My lord, I as a private individual, a citizen, may have filed a suit that this is my property which somebody has declared as a waqf. That would be governed by the judicial adjudication, what the court will ultimately adjudicate upon. Lord, I don't think there can be any objection to this. If there is a dispute between private parties and a waqf with regard to the waqf property, it would not be a waqf because it would be governed by the adjudication of the competent court. Second, is in dispute or is a government property. Lord, kindly appreciate, my lords. Waqf, we are dealing with waqf by user. Lord, first category of waqf is I have a property, I dedicate it to the Allah for a particular reason, my lord. It can be for a mosque, it can be for school, it can be for hospital, it can be for Musafir Khana, it can be for Yatim Khana, several, because they say religious, charitable or pious purpose. Nobody has a right over the government land because the government being the owner of the land would mean the entire country is the owner of the land and the government holds the land in trust for and on behalf of each and every citizen. Number one. Number two, waqf by user. There are judgments that the government, even in case of a waqf, that government can protect its property if it is declared to be a waqf. There is a Supreme Court judgment. I will not cite one paragraph from there. Secondly, when we say waqf by user, by definition, the property belongs to someone else. You have acquired right by continuous use. I hope I'm clear, my lords. Waqf other than waqf by user My property, I dedicate it to Allah, my lord, and it becomes a waqf. But waqf by user, by definition, means by long usage, it acquires the property, it acquires the character of a waqf, and therefore necessarily either a private property is used for a long period or a government property is used for a long period. Now, my lord, the question is how to decide whether this is a government land or not. For the time being, my lord, forget waqf by user. But suppose there is a building standing on the property, which, my lord, can be a government property. It can be a residential building, it can be an industrial building, it can be a temple, it can be anything. The question I'm posing to myself is, my lord, can the government not examine that whether this property belongs to the government I'm holding in trust for and on behalf of 140 crore citizens or not? Lord, that is provided for in 3C, which your lordship put.
That is what their condition is.
Yes.
That maybe an officer above the collector.
Correct, Manoj.
So
I'll answer that, Manoj.
He is a government officer.
Yes.
The government deciding its own claim.
I'll answer that. I'm conscious.
And given a finality to that.
My lord, that is where I may say, my lord, with sense of responsibility, it was not only just misleading argument, but it was a false argument, and I'll demonstrate that. My lord, what happens, my lord, when a revenue correction process starts, revenue records are being corrected, the revenue authorities decide whether it is a government land or not. But revenue authorities decide only for the purpose of revenue records and correction of records. They cannot decide the title. I'll come to that, my lord. I'll satisfy your lordships. And it is not final. My lord, repeatedly your lordships were told that there is complete absence of access to justice. I am a judge in my own cause and my order is final. I'll demonstrate that, my lord, that to be not just misleading but false. Please come to page 12 of my written submissions where I have quoted 3C. Now, this is the identification. My lord, initial bill was that the collector would decide because on land revenue laws, your lordships are aware, every state has a land revenue law and the collector decides whether the government is the owner of the property or it's a private property. But the objection raised by many was that collector himself is the custodian in this district for the revenue purposes, for the purpose of government property. So he will be a judge in his own cause. That was the arguments against the collector being the adjudicator, and therefore it was suggested by JPC that let somebody else be the designated officer. Please have a look, my lord. Any government property identified or declared as waqf property before or after the commencement of this act shall not be deemed to be a waqf property. Now, 2, this will have to be read with 2. If any question arises as to whether any such property is a government property, the state government may by notification designate an officer above the rank of the collector, hereinafter referred to as the designated officer, who shall conduct an inquiry as per law and determine whether such property is a government property or not and submit his report to the state government. Now, please see, provided that such property shall not be treated as waqf property till the designated officer submits his report. I'll come to, my lord, what is the intent. If your lordship wants to delete this, please delete it. It's in their interest, my lord, that this provision is made. And I'll demonstrate that.
So delete what, entire section 3C?
No. The proviso, they were objecting to the proviso.
But then, no, they are not only objecting to proviso, they are objecting to the entire section.
No, I said this when I read proviso, but I understand. No, not for entire section. 3. In case the designated officer determines the property to be a government property, he shall make necessary corrections in revenue record and submit a report in this regard to the government. The state government shall, on receipt of the report of the designated officer, direct the board, that is Waqf board, to make appropriate corrections in the record. Lord, the only consequence of the exercise undertaken by the designated officer under 3C will be that revenue record and the board record will be modified, will be corrected. Now, please come to, my lord, I will answer that question, my lord, but before I answer.
1 minute, first let them.
Yes, I'm sorry. There is a remedy. इसमें नहीं होगा.
So, but the only consequence of exercise under section 3C,
Yes.
is correction of records and nothing further.
Correction of record of revenue record and the board record. Nothing further, and this is what I have said on affidavit which is served upon them, but nobody, my lord, brought to your lordship's notice while arguing that my land is taken away. Please have a look at
But
page.
What is the purpose? Then it will be only a paper entry.
It would be a paper entry if I want to establish, I means the government wants to establish its right of title, right of ownership. The government will have to file a suit for title. If,
What that?
please have a, I'm reading my affidavit. Please have a look at page 95 of my affidavit. This, my lord, in all fairness, my lord, when affidavit is filed long back, should have been brought to your lordship's notice. Because the argument repeatedly made was that this is wholesale takeover of WAQF. First, revenue entries will be corrected and the entries in the board will be corrected so that if anyone is dealing with the trust property, he would know that as per revenue record, government is the owner and not the WAQF. Now, my lord, please come to page 95 of my counter, paragraph 152.
Para?
152, page 95 of my counter. Yes. Kindly keep, my lord, my counter handy. Does your lordships get, my lord Justice Masih? It is further submitted that the function of the designated officer in this regard is limited. It is submitted that in case the officer's report states that the property is government property, the revenue record will be updated to reflect the same. It is submitted that the designated officer is not making a final determination of rights because it is an established principle that mutation in the revenue record is only evidence and but not conclusive of ownership, which should be evidence of possession. No, there is a typo. It is submitted that if the designated officer determines the property to be a government property under section 3C2, it would result in the government being reflected as the owner in the revenue record. Now, please see 153, very important. It is submitted that it would be open for the affected or aggrieved party in such case at any stage to approach the WAQF tribunal under section 83(2) of the Act. It's not final. There is no denial of access to justice. I'll come to that section, my lord.
Which paragraph you are reading?
153, my lord, page 96. Lord, I'll just read again, my lord, 153. It is submitted that it will be open for the affected or aggrieved party in such a case at any stage, even if, my lord, entry is changed, to approach the WAQF tribunal under section 83(2) of the Act. It is submitted that final determination with regard to the title would therefore be made by the WAQF tribunal or in appeal by the Honorable High Court and the Honorable Supreme Court. It is submitted that the final rights of the parties would be subject to the court's decision. It is submitted that updating of the revenue records as provided for by section 30C2